started with an ad in the New York Times. It was 1960, March 29th. And the Times ran this full-page ad soliciting donations for the Reverend Martin Luther King Jr. and for college students in the South who had been fighting segregation there. And this fundraising appeal, heed their rising voices. It listed a bunch of ways in which the students in particular were allegedly being harassed and terrorized in the South. Now, there was a city commissioner in Montgomery, Alabama, whose name was L.B. Sullivan. And L.B. Sullivan saw that ad and decided he would sue the New York Times over that ad, sue them for libel. The ad in the Times accused Southern officials of violence and intimidation, of violating the Constitution, and Mr. L.B. Sullivan said that that meant that the Times had defamed him as a Southern official because he said there were details in the ad that were exaggerated or incorrect. When he sued the Times, this was the headline in the local paper in Montgomery: "State finds formidable legal club to swing at out-of-state press." In his new book, which is called Murder the Truth, New York Times reporter David Enrich describes what happened next. He says, quote, "Sullivan's lawsuit went to trial in the Montgomery courtroom of Judge Walter Jones, who maintained segregated seating, was a devout promoter of all things Confederacy, and who believed in what he called the white man's justice. As the Sullivan trial was about to get underway, some prospective jurors showed up to court in Confederate costumes, toting pistols. Quote, "It took the jurors barely 2 hours to return a verdict against the New York Times. The paper was ordered to pay Sullivan $500,000. It was the largest libel judgment in the state's history. Quote, for racist Southerners, this was the equivalent of a green light. The courts could be used to scare the press into silent submission. The New York Times, fearing a tidal wave of litigation, banned its reporters from setting foot in Alabama. The Times' lawyers urged staff not to write articles that detailed the state of Alabama's institutionalized racism." That wasn't the end, though. The Times eventually got this case with L.B. Sullivan taken all the way to the U.S. Supreme Court. And in 1964, the Supreme Court surprised everybody with a landmark, unanimous Supreme Court decision that changed journalism in this country forever. In the simplest terms, the precedent means that there can't be free speech and a free press if news outlets can be sued into oblivion over mistakes or good faith errors. The court established a new standard. A public figure suing a media outlet for libel would have to prove that the outlet knowingly lied or acted with reckless disregard for the truth. David Enrich writes in his new book that after the Sullivan decision, quote, "Reporters uncovered wrongdoing in Vietnam and the White House and the Pentagon. It was not a coincidence that the Washington Post cracked open Watergate in the years after Sullivan. If the burden of proof in a defamation case had still rested with the defendant, with the press, and if even honest mistakes had remained punishable under the law, the cost of publishing such a series of investigations might have been prohibitive." As his presidency circled the drain, Richard Nixon blamed the Sullivan decision and had his administration craft legislation that he hoped would supersede the precedent and put the media back in a pen. Richard Nixon did not succeed at putting the media back in a pen, but he would not be the last to try. David Enrich makes a compelling and alarming case in this very important new book that the legal protections that undergird the free press in this country, that make it possible to do adversarial, investigative journalism in this country, they're on much shakier ground than we may realize. Donald Trump and his allies have made no secret of their desire to criminalize journalism, with constant attacks on the media as the enemy, and an explicit campaign promise from Trump that he would somehow, quote, "open up America's libel laws." That means something specific. Trump's billionaire supporters have already launched aggressive legal attacks on media outlets that are specifically designed to bankrupt those outlets and shut them down, and they have had some success with that. A once fringe right-wing idea that the whole New York Times v. Sullivan precedent could be overturned is now publicly supported by 2 Supreme Court justices. The attack on this foundational protection for the free press in this country has been a long time coming from the far right, but it looks like it may finally have arrived. David Enrich joins us next. Stay with us.